In the case of McGowan v. Maryland, the appellants contend that Maryland statutes have violated their 14th and First Amendment rights. We are here today to sort out a problem that wasn't a problem in the first place. Let's set the record straight. This case is not about a violation to one's right to equal protections or free exercise. The appellants contend that the law was designed to encourage church attendance and aid the conduct of church services. The evidence they maintain is that these laws were created and motivated by religious forces. And because of the origin of these laws, there is no guarantee to the separation of church and state provided by the First Amendment. In response, we find this analysis to be outdated. Yes, the laws Mr. Silbert referred to were religious when enacted, but we're in a different time now. For example, Article 492 uses the language that work is forbidden on the Lord's Day, but that's only because it dates back to language used in colonial times. Even then, 492 is not the section we're dealing with. The section we're dealing with is 521, which in no way says anything about the Lord's Day. It merely says that on Sunday, certain items cannot be sold, and it permits certain items to be sold which are of basic necessities. Unlike the laws in colonial times that prescribe to church attendance and the prohibition of liquor and gambling, the Sunday laws in Anne Arundel County provide a different purpose: recreation. There is no commercial activity except for those relating to recreation. The appellants claim Article 521 has violated their First Amendment rights, but there is no evidence that the law interfered with their religious practices. In fact, there is no record that the defendants subscribed to a religion at all. This law plainly and clearly does not establish a religion. If anything, it encourages activities that would not ordinarily be associated with religious observances. None of the defendants have shown a significant financial burden, contrary to what the opposing side believes. There is no law saying somebody at the beach can sell and somebody a block away cannot sell. The Maryland law says if the item is one that is customarily sold at a beach house or a bathing beach, then it is permitted. The appellants were arrested because those items did not come within the exceptions set forth in the Anne Arundel County statute. They have violated the law, not the other way around. This is not a case concerning the First and 14th Amendment. This is a criminal case and should only be seen as such.